Good morning, everyone, and thank you so much for joining us today. My name is Kelsey De Rinaldis, and I'm the Assistant Cultural Affairs Officer here at the U.S. Embassy in Tokyo. Before we begin, I'd like to remind everyone that today's event is on the record and will be recorded. Following the opening remarks and presentation by our keynote speaker, Daniel Castro, we will open up the session for question and answers. We invite you to submit your questions throughout the session in the Q&A box on your screen. We will take questions from there. Additionally, throughout today's program, we will be conducting audience polling. We encourage you to participate. It is completely anonymous. So without further ado, I'd like to introduce my colleague, Sharon Node, who is an economic officer here at the U.S. Embassy in Tokyo. Sharon, over to you.
Thank you, Kelsey. Can everyone hear me? Great, thank you. Good morning, everyone. My name is Sharon Node, and on behalf of the U.S. Embassy, I'd like to extend a very warm welcome to webinar participants and to our guest speaker, Mr. Daniel Castro. We're pleased to see well over 200 people registered for today's session. And this, I think, indicates the relevance and timeliness of the topic of cross-border data flows. I'd like to give some brief context for why we've asked the IT Innovation Foundation to share its expertise on this important topic. As many of you remember, Prime Minister Abe issued a call in early 2019 for the G20 to ensure the free flow of data across the world, while at the same time protecting privacy and security. That vision is compelling. The ability to transfer digital information across borders is absolutely essential to economic growth and opportunity. There are now more than 4 billion internet users across the planet. Each day, they generate over 2.5 quintillion bytes of data. And that figure, as inconceivable as it sounds, is expected to increase tenfold in the next 5 years. Cross-border flows of data have become critical to commerce and trade. They currently drive 22% of global economic output and will add as much as $11 trillion to global GDP by 2025. So data flows are vital, and not just for big multinational tech firms, but for traditional industries like auto manufacturers and banks and hospitals. And for small and medium-sized businesses too, the companies which form the backbone of the service sector and are a crucial part of the manufacturing and export supply chain. At the same time, because international flows of data so often involve personally identifiable information, we must also recognize privacy and data security as essential. Essential not only for organizations to have legal certainty, but also for businesses to build consumer trust. Around the world, countries are developing their own approaches to privacy that vary significantly in their data policies and laws. And this is leading to a more fragmented regulatory landscape. The implications of a fragmented regulatory landscape are profound. The costs are felt in real dollars, and compliance with a host of regulatory regimes can undermine policy objectives, such as innovation and economic growth. And so the challenge before us today is, how do we protect data while at the same time enabling it to flow freely between countries with different approaches to privacy? And so to help us address that big question, I'm pleased to introduce Mr. Daniel Castro, who is Vice President at the Information Technology and Innovation Foundation, the ITIF, and Director of ITIF's Center for Data Innovation. Mr. Castro is an expert on a variety of issues related to information technology and internet policy, including privacy, security, intellectual property, and internet governance. He has been quoted in numerous media outlets, including the Washington Post, the Wall Street Journal, National Public Radio, USA Today, Bloomberg News, and more. I'm sure Mr. Castro's presentation will spark many provocative thoughts and questions, and I encourage you to share these in the Q&A box. So thank you again for joining us today, and I now turn the floor over to Daniel Castro.
Well, thank you so much for that welcome, Sharon and Kelsey. It's really a pleasure to be with you this morning to talk about these very important issues of cross-border data flows and how it relates to our economic security at the national level and at the global level. So to begin, I'd like to first introduce a bit more about my organization, the Information Technology and Innovation Foundation, or ITIF. So I work for a think tank that focuses on the intersection of technology, innovation, and public policy. And as we emerge from this global pandemic, it's clearer now than ever that digital innovation is a key driver of economic security. And so in this globally connected economy, access to data is what enables digital trade. And so issues of cross-border data flows have moved from what used to be a very arcane policy topic to one that is of paramount importance. Because the global free flow of data is necessary to enable the digital economy to flourish and spur innovation, increase trade, and generate the higher paying jobs over the next decade that every country needs to be successful. So to begin, I'd like to talk about the different types of waves of digital innovation we've seen over the past few decades, because that's led us to where we are today. So if you think about the first wave, you can think about this being the mainframe economy, where the businesses that were most competitive were those that figured out how can they leverage this new IT innovation that came out, these massive mainframes. It was companies like IBM that shaped the competitiveness of different firms. And then we moved into the network economy, later on, where you had personal computers, local area networks, companies like Microsoft and Lotus that computing to every desk in the office. And again, it was companies that figured out how they can leverage this new connectivity, this new computing power to be competitive. And of course, most recently, most people are familiar with the internet economy, the late 90s, early aughts, where you had the early internet giants like Yahoo, Amazon, the rise of the dot-coms, where we had the promise of a globally connected economy and the ability to do business globally and communicate globally and see productivity increase and see business opportunities increase. And again, we saw massive disruption in the market as new firms that leveraged these capabilities were the ones that could be most successful. What's interesting is that we've seen such rapid innovation over the past 20 years. We've quickly moved on to the data economy, where the focus here is around social, mobile, analytics, and cloud. And the companies that can leverage these technologies are the ones that are creating some of the most important innovations in the marketplace. But we're already rapidly leaving the data economy and we're entering the algorithmic economy, where the question now is, how can you use technology to automate processes with whether it's artificial intelligence and machine learning, the Internet of Things, blockchain, or robotics. There's so many possibilities now to leverage algorithms to be more competitive in the economy. And that's where there's so much focus. But in both the data economy, where the focus was on analytics, and the algorithmic economy, where the focus is on automation, both of these depend heavily on data. And that's why this discussion of cross-border data flows is so important today. So what we've seen in both of these, the data economy and the algorithmic economy, is the rise of what we call data-driven innovation. This is where better data that is more precise, data that's more accurate, data that's higher resolution, and data that's more timely is leading to new types of innovations. And as we've seen over this past decade as well, we've seen the massive amount of data that's being generated, not just being stationary, but really flowing around the globe. Now I'll pause here to note that, as discussed earlier, we're going to be doing a number of polls throughout. So you'll see these poll questions pop up, and then you'll have a chance to respond. And these responses are anonymous. As we've seen, between 2005 and 2017, cross-border data flows have grown 148 times larger in that period since 2005. So the question then becomes, why does all this data-driven innovation matter? And it matters for a few reasons. First, better data means better decisions. This is what we talk about when we talk about data analytics. It also means, how can we increase automation with AI and the Internet of Things? And all these capabilities come together to boost productivity, improve public safety, address environmental sustainability, improve healthcare, and even create a more effective and efficient government. And when governments confront this type of innovation, there's generally two different types of approaches. One is the precautionary principle. And here the response is, when you think about the precautionary principle, it's the principle that government should limit the use of new technologies until it's proven safe. The idea here is that it is better to be safe than sorry. And the clearest example of this is when there's a concern about a new technology, and then government might move to ban it. And we've seen this, for example, with ride sharing. We've seen this with e-scooters in some countries. And we've seen this with other new technologies, including some uses of artificial intelligence. In contrast, the innovation principle says that the vast majority of new innovations are beneficial and pose little risk. So the role of government is to really encourage this type of innovation. And the point of the innovation principle is not that the market will always get things right. Sometimes it doesn't. And it doesn't mean that government should never intervene. There's always a role for government regulation and oversight of markets. But it does mean that when we're talking about new innovations, especially in a rapidly moving digital economy, taking a wait and see approach can be very beneficial. We should wait and ask, how will markets, platforms, and consumers respond to the problems that arise? What are some of the potential unintended consequences of regulatory solutions? And are there alternatives to more formal hard law, such as soft law options, voluntary codes of regulation, self-regulation, or voluntary codes of conduct? And these two different approaches are very different worldviews. In one, the government sees itself as an important roadblock to protect consumer safety. In the latter, government sees itself as a guardrail to accelerate the opportunities to use these technologies while protecting public safety. Now, similarly, there is two different ways that countries are approaching the idea of digital trade. One is a protectionist approach, and we see this in many of the trade discussions and debates. The protectionist approach says that the goal should be on boosting domestic firms. And so the policies are often focused on restricting foreign service providers from processing domestic data. The alternative approach is a free trade approach, which is to say that the focus is on how can you minimize barriers to trade, and the goal is to allow foreign service providers to have access to different markets for data processing. Now, when you think about how these different principles come together, you can see that there's some very different ways that national governments approach data policy, data regulation. So if they're a country that embraces the precautionary principle and this protectionist type model, they're going to be what we would call a data isolationist. They should say that data should be tightly controlled and stored locally. Now, if it's a country that is protectionist but also embraces the innovation principle, then they might be more of a data nationalist. So they're saying data should be stored locally to protect security, privacy, or the economy. And an example of that is China, which has taken both a very aggressively pro-innovation approach, but also a very protectionist approach to its trade policy. Now, if you move over to the free trade side of this, you of course see countries and regions that are embracing the precautionary principle in their approach to new technology, but they are also generally free trade. So their approach is this interventionist approach, which is to say that unless other countries adopt our data rules, data should be stored or data must be stored locally. And this is what we're seeing with the European Union. And then finally, we have this kind of innovationist approach, the approach that both embraces the innovation principle, but also embraces the principles of free trade. And this is the idea that data should be able to flow globally to allow access to the best products and services and to facilitate access to these different markets. Now, when we look around the world, some of our research has found that the amount of data localization laws have increased enormously over the past decade. This idea that data will flow globally unfettered in a natural way just doesn't occur because so many different countries are enacting barriers. They're requiring data to be stored locally, or they're requiring data to be processed locally. And this is a global problem, and it raises costs for startups and businesses. For example, it can increase the cost of data hosting by about 30 to 60%. And this can have a significant impact at the national level by raising GDP. And if you look at the type of data that is blocked, some of this is very important information. It can be accounting, tax, or financial information. It can be government information. Of course, a lot of this is personally identifiable information that's kept in the country for various reasons, but inhibits the use of many important and innovative services. Now, what we've also seen, not only the rise of data localization laws, but we've also seen the rise of data protection laws over the past decade. And this change has come very quickly. The average number of countries that have created new data protection laws per year has nearly doubled in the past decade compared to the one before that. And now, you can look around the globe and see so many different countries that have implemented new data protection laws in this recent period. And of course, the one that we've heard the most about globally is the GDPR, the General Data Protection Regulation, which Europe has claimed is the gold standard for data protection laws. And now many countries are incorporating elements of GDPR into their own data protection frameworks, in part because the EU is using its national adequacy determinations to control access to its market. But unfortunately, the GDPR hasn't lived up to its hype, even by the standards of some of its proponents. And since the GDPR came into effect pretty much 2 years ago, we now have clear and mounting evidence of some of these problems. First of all, many websites have simply given up on GDPR. Many businesses have given up. They found that the risk or the cost of compliance is too high. And so they've simply decided to block Europeans from visiting these sites. 2 months after GDPR went into effect, a third of the largest US news websites had blocked access to the European Union. And nearly a year later, over 1,000 US news websites still were blocking EU users, including some of the major publications. Others simply decided to charge European customers more so that they could cover the cost of these additional compliance measures. Another problem is that GDPR has not been consumer friendly. At the time of transition to this new law, consumers' inboxes were overwhelmed with privacy notices. like the ones you see here. And what's interesting is that these privacy notices have not become simpler for consumers to understand. Last summer, the European Commission found that 2/3 of the Europeans that polled still had never even heard of the GDPR, and the majority in countries like Spain, Romania, and Hungary did not know about their national data protection authorities, which is who they would go to if they had a privacy complaint. Another problem here, and one of the clearest things that GDPR was supposed to do, was to increase trust in the internet, but it's had virtually no impact on consumer trust in the digital economy. 6 months after this law went into effect, consumer trust in the internet within the EU itself was at its lowest in a decade. In a survey from last summer, 4 out of 5 Europeans who have provided information online feel they have no control or only partial control over this information. And again, these are surveys conducted by the European Commission itself. Now, if there's one place you might expect to see an improvement, it would be in data breaches. But the number of data breaches in the EU have remained high. It's not clear if they've gone up or down, partially because there's a lot of over-reporting that's happening now. But by almost any standard, the number of data breaches is still incredibly high and significant. And this is important because we know that companies have spent millions on compliance. The global Fortune 500 companies alone spent around 7 billion euros on compliance. And yet, we still live in this world where data breaches are the norm. But probably one of the worst examples of GDPR's failures is that it's created new vulnerabilities. Companies are so worried about the fines for non-compliance that they're making mistakes. So James Paver, who's a researcher at Oxford University, asked how effectively companies were protecting personal information from wrongful disclosure. So he asked 150 companies for personal data on someone else using the GDPR's right to access. In this case, he was asking for data about his fiancée with her permission. He found that only 40% of the companies correctly verified his ID and then denied the request. Others accepted very weak forms of ID, such as an email address with that name, or simply turned over the data without asking. Some ignored the request, and my favorite is that 3% simply deleted the account, which was of course not something that his fiancée was expecting. Now, I think the most significant problem with the GDPR is in how it's constructed. The expectation is that other countries will fully adopt Europe's data protection laws. Other countries must be deemed adequate by the EU so that data can be transferred globally. And it's not just the overall framework of the GDPR that must be accepted by other countries, but all of the specific details about what government can access and under what conditions. And that level of control threatens national sovereignty. And it doesn't respect the many ways that countries, even countries with very common and shared democratic principles, might approach these important issues of national security, privacy, consumer protection, and the economy. And so what we've seen this summer is that in a very significant court case called Schrems 2, where Max Schrems brought a case against the data that was being shared about him, a European, and being sent to the United States. The European Court of Justice ruled that even when there are these minor differences in national laws, that can invalidate agreements to share data outside of the European Union. In this case, it invalidated the EU-US Privacy Shield, which was set up to allow the transfer of transatlantic data. And this type of decision not only creates instability for firms, it's not sustainable for businesses that want to operate globally. And even though Japan has adequacy under the GDPR today, this case shows how easily this guarantee can be taken away. So the conversation that I think we need to be focused on is, how do we move forward? We need to have a global alternative to GDPR, which is good for the countries that adopt it, but doesn't force other countries to abide by it. I think there's a few principles here that we can look at. One is developing shared data protection principles. So how are we going to treat these common problems of ensuring data is protected in this global economy? And there's a number of very good principles that have been developed over time that I think there's actually quite a bit of agreement on. The second is, how can we seek regulatory interoperability rather than this requirement for harmonization or adequacy? The third would be, can we allow chains of trust for data so that the data protections flow with data itself? And here the idea is that instead of requiring that data can only go to another country if that country is set up in the exact same way, put the risk on the company that collected the data in the first place. And if they make a business decision to transfer data abroad, they're still held responsible in that original country where they've collected that data, not only for how they're processing the data themselves, but how any of their partners are processing it. And by creating that chain of trust, you can use contractual language to ensure that consumers have redress directly with the company they do business with, and businesses have redress if they have a partner that mishandles information. And it creates more reliability throughout this whole ecosystem. The fourth principle is working to expand this group of countries that embraces both free trade and the innovation principle. So these data innovationist countries. I think the US is in this category. I think Japan is in this category. And I think, some of the principles that have been espoused throughout the G7 and some of the other international forums reflects the shared commitment to pursuing both of these values of free trade and a pro-innovation approach to regulation. And finally, it's important that we establish global data trust for research and commerce. The idea of a global data trust is creating a shared pool of information, a shared pool of data, and a shared governance framework so that you can collect data for machine learning, for health research, for security research, and share it easily among countries that agree to common governance principles. Right now, too often, we're national data sets instead of global data sets. And when we look at where innovation is occurring, again, going back to that original slide about these waves of innovation, it's occurring now with automation. And all that automation requires massive amounts of data. And this isn't going to be simply national level data sets. We need global level data sets. And global data trust are one way to pursue that opportunity. And here's also where I think a focus on a GDPR alternative is crucial. Here's where the APEC cross-border privacy rules is really a powerful model for the world that I think has been underappreciated to date. This is many of these principles. It recognizes the importance of free trade. It's based around this idea of interoperability. It's based around this idea of chains of trust. And it also, the way it approaches data protection, it uses a risk-based framework. So it doesn't say all data is the same. It doesn't say we need a one-size-fits-all model to data protection. Instead, it allows companies to make a determination of risk based on the specific context of what information is being collected and the risk that it creates. So I think there's a really interesting opportunity to have an important discussion about how to continue to promote the global free flow of data, how to do so in a way that promotes economic security, and how Japan and the United States can work together on what I think are very common and shared principles. So again, I really appreciate the opportunity to share some of my thoughts with you today. I'm looking forward to the conversation and questions that you have. Thank you.
Wonderful. Thank you so much, Daniel. Now, we will open the session for question and answers. As a reminder, please type your question in the Q&A box. So while questions are beginning to come in, the first question we have is, should companies develop different business models based on the level of data protection in different places? For example, should companies make plans on how to operate in data-free flow countries, as well as plans on how to operate in data-controlled countries?
Yes, that's a great question. That's something that I think so many companies are wrestling with. We've seen many firms start hiring data protection officers because they have to deal with the different and varied laws around data. And so I think the goal for companies, should be to figure out how can they do two things. One, get data within their organization, especially these multinationals that have many footprints. How can they make sure data can flow within their organization? And how can they get data that flows to their customers and suppliers and from their customers and suppliers? Of course, for every country, that's going to be different. But most of the companies that are focused on automation, they really need to have access to all of their data. They can't have access to 80% of their information about their employees and be able to run an employee wellness program, for example. They can't have access to 60% of their supplier and supply chain and be able to perform analytics to understand the different geopolitical risks of doing business. So what I think we're seeing is that countries that have these barriers to data flow end up really hurting the long tail of their economy. So for example, a country that maybe is supplying goods to a manufacturer, if that manufacturer can't get good information, good intelligence about their suppliers because of some of these data localization laws, they're going to look for a supplier somewhere, and that's going to hurt local businesses. And so what we're seeing is really the network of countries that are allowing data to be shared together are going to be the ones that grow the fastest and grow the strongest. And it really kind of tilts the playing field away from countries that haven't figured out how to master this challenge. And so, there are, I think, countries that are going to be somewhat left behind in this global race of how do you move ahead. And companies are going to have to reorient their businesses away from those areas the same way they do when there are tariffs or other types of trade restrictions that interfere with their ability to operate.
Wonderful. Thank you, Daniel. Great. And as you see, questions are starting to come in. So I'm going to go ahead and move down the chat box here, or the Q&A box. All right, so we have a question here. What is the significance to promote CBPR when the US and China conflict over data issues, and when the US-EU Privacy Shield must find a successor? What are your thoughts?
Right. So I think and this somewhat gets to the first question as well. The real challenge globally is how do all of these different countries work together to build a global governance system that allows data to flow. We've built the technical infrastructure for this, the internet, which is the marvel of our modern society. And it technically allows the information to go anywhere, but we have these policies that prohibit it. And so, the point of the CBPR is that this is a framework that is being, increasingly looked at as part of trade agreements as a way to allow multiple countries around the globe to share data in a way that protects consumer privacy, protects national security interests, and allows, of course, countries to retain that sovereignty of deciding how exactly they want to enforce these types of laws and what types of protections they want to have in place. And so, the conflicts that we're seeing, especially the ones that we're seeing, for example, over the US-EU Privacy Shield, they're really minor. The debate there is about the national government, when law enforcement should be able to access information under certain conditions and the types of notice they need to apply. And it's a very small difference actually between the United States and Europe, but because there is that difference, that invalidates the entire Privacy Shield agreement. And that's where the GDPR is, some would say that's its strength, that it's so rigid, but something so rigid also breaks a lot of things. And in this case, it's breaking the global flow of data. And that's why we need to be pursuing alternatives.
Great point. And on that, we have a few more questions as well. So another question here with CVPRs being established for so long, but with so few companies signing up for them, how do we encourage more people to adopt them, more companies to adopt them?
Yeah, so one thing we have to remember is that there are so many companies who have probably never heard of CVPRs. So many startups, for example, that I talk to, they haven't thought about these types of questions, and they really only confront them when they go to expand globally, when they go to enter a new market, and they realize for the first time that this is a problem, and maybe they can't go there, or maybe this is raising the cost of doing business, or maybe it's forcing them to use a second best option for data processing or data analytics. So we really need to have governments somewhat evangelizing this opportunity of, here's a way to scale globally. I was talking with a startup recently in Estonia, and one of the questions that came up was, why are so many Estonian businesses successful globally? And the answer that this entrepreneur said was that because Estonia is both so small, every entrepreneur there, every startup there knows that they have to scale globally if they want to be successful. It's not about starting a domestic market and then going global. The initial startup is focused on going global. And we don't have enough business to confront those data questions early on, so end up with a very convoluted setup, and they're having to wrestle with these questions late in the game. Or you have very large companies who can afford to pay many lawyers to do all the different privacy policies, to write all the different privacy policies that are required to operate. And these policies get longer and longer, and they get more and more confusing to consumers. And what to me is such a problem with that is we keep moving further and further away from the goal, which was how do we protect consumer privacy. And when we make it so complicated, we're not actually achieving that goal. We're having companies spend more money on lawyers than on privacy engineers, and we're not making consumers. And so I think one of the ways we can talk about CVPR is an antidote to that problem. Here's a simpler solution than spending, than making your next hire a lawyer. Here's a way to move forward, but it's going to have to be something done in partnership with government.
Great, thank you. Yeah, I think partnership is necessary to move this forward. We have many more questions here, so let me move on. I think coming back to one of your earlier slides, talking about how we can classify a country as a whole as protectionist or innovationist. And in a single country, we see diverse thoughts about data protection, sometimes very different among departments, ministries, or agencies. Does protectionist mean that the legislation in the country is protectionist?
So that's a great point. And of course, any attempt to put countries into 4 boxes is an oversimplification. There are, of course, multiple strands of thoughts, and sometimes it depends on specific technologies. So on some technologies specifically, you will see a very precautionary principle approach, and then on others, there'll be more of an embrace of the innovation principle. Similarly, on free trade, sometimes you'll see a very clear national policy that is protection, but sometimes you see very specific markets or sectors where a country still retains a protectionist bent towards its trade policy. Of course, here I'm mostly talking about digital policy, And so I'm talking about, areas where we're seeing specifically within the digital policy context, a protectionist approach. And those tend to be in countries that are large and are trying to model China, where they see China, using its protectionist approach to grow domestic companies, somewhat successfully, of course. And they're saying, for example, maybe Brazil, saying, you know what, if we keep foreign companies out, Brazil is a large enough market that we can develop domestic firms without competition for some period of time. And then eventually we think they'll be competitive. That's not a winning strategy, I think, long term, but that's the type of model we see in certain countries. India, of course, is another one that has occasionally pursued that.
Thank you. And so coming back to CBPR, there have been a few questions here. Do you think it's feasible to kind of carve out CBPR from APEC to develop extended framework for innovative countries? And, CBPR is emerging as the new standard, or is it emerging as maybe the new standard, considering it may not work when transferring data to the EU?
So I think right now we're seeing two paths. And I think we're also seeing, so one path is, of course, a lot of countries have quickly moved to mirror GDPR as much as they can with the idea that they want adequacy or they want to make it easier to access European data. The challenge, of course, here is that, it was a law written for European countries, mostly wealthier European countries. And it was a law that was written even before, countries, even before in the EU, they were considering artificial intelligence. The original law, although it went into effect in 2018, was drafted in 2014, before there was a focus on that technology. There was also, for example, no focus on blockchain. So blockchain is fundamentally incompatible with GDPR because GDPR has a right to erasure, a right to delete data, and blockchain is fundamentally about how can you have data that cannot be ever erased from the blockchain. So these are ideas that are incompatible. And so, the challenge that we see is that some countries have raced forward with these rules and they're hitting all these problems. They're coming up on the cost issues, they're coming up on some of these technical problems, and they're having to go back and say, well, what comes next? GDPR is not going to be the final and last word on data protection. It must be up at some point, even for Europe. And so we're also having the second track of countries that are saying, GDPR just definitely isn't right for us. What else can we do? And so I think that's where, CBPR is offering a really interesting alternative. It's showing, this idea of interoperability without harmonization. And it might be a really important path forward for the EU to think about, even as they're moving forward, how can they create some kind of compatibility with APEC and CBPR so that so many other countries that have opted into this regime can automatically get access. Because it is a problem in Europe as well. I mean, European companies want to scale globally and they face the same problem when they open subsidiaries or are doing business abroad and they can't send their data. So it's not just kind of foreign critics of Europe, it's coming domestically of companies saying, we need some alternatives here.
Great. Kind of pivoting back to the US here, when will the US develop federal level data privacy laws to join APEC CBPR framework? Does the US need to have a federal level privacy law? And how does that interact with GDPR?
So that's a fantastic question. And I think it's one that the US, more countries should be asking of the United States. And I think there's two answers here. One is the kind of practical question of Congress is currently considering a number of federal privacy laws that would create a single national standard for a lot of consumer data, including internet data collected online. Separately, we have a lot of, we have some state laws that are creating a de facto national standard. In particular, California passed a law a year ago that went into effect in January and is being enforced as of this summer that has a significant impact on how companies are doing business. We also, of course, have many US companies are multinational, so they're complying with the GDPR. So they're also already following a lot of the same principles. And then finally, what I think is often left out from the conversation is while the US does not have a single federal privacy law, a single comprehensive law, the same way that Europe has the GDPR and some other countries have a single national framework, the US has a number of federal privacy laws that are sector specific. So we have a federal health privacy law, we have a federal privacy law around education data, a federal privacy law around financial data. And these federal laws are hugely important to protecting the most sensitive information about Americans, as well as foreigners who store data with US companies. And we do have strong enforcement through the US Commission. In fact, even though the GDPR is known for having these high fines, it was the US fine against Facebook that set the global record. So I think we do have very strong enforcement. We have a strong record of enforcement. We have good privacy laws, but we don't have this national law. And I think it's a little bit of a misreading to say, because the US doesn't have one national law, it doesn't have data protection. But unfortunately, I think that's become the narrative. And so it is important for the US to address that problem and that shortcoming by creating a federal privacy law. Our think tank's actually done a lot of work outlining what this should look like. But it should be based in this risk-based approach where we don't take a one-size-fits-all and say all data must be protected with the highest standard. We should say, well, no, the most sensitive data and these very sensitive critical use cases, that needs the most protection. We should focus companies' attention on where the highest risk is and then allow them to mitigate risk on lower risk data in different ways where they are held accountable for data breaches and other problems, but allow them some flexibility.
Wonderful, thanks, Daniel. So looking at the chat box here, there's a few questions again on whether GDPR is a failure or not, and if it has a positive impact to create some type of progress, and kind of what would be the next action that should be taken after that, considering various countries in the international community develop their own policies, and how this analysis that that GDPR does not benefit consumers is recognized by the EU member states. Is there a conversation whether GDPR should be revisited? What are your thoughts there?
So there's been a number of position papers and policy papers that have come out pointing to some of the different inadequacies and failures of the GDPR. And I think European policymakers are aware of these problems. And in fact, the clearest example of, I give the European Union a lot of credit for leading the conversation on this important topic. I think, in terms of critiques level against the GDPR, I don't mean that as a critique against the EU itself or against the European Commission or the European Council that has come up with these rules, because they were the first to do it in that sense. They created rules that other countries have looked to as a guidepost. And I think it's obviously easy to critique what's done. It's much harder to be down there writing the rules and getting the political compromises to get it accomplished. So they should get a lot of accolades for driving that conversation. But even within Europe, there's a lot of recognition that the policies aren't working. So during the pandemic, for example, when countries were faced with this clear trade-off between protecting consumer privacy, protecting individual privacy, and being able to respond to a life and death scenario where we needed to know information about, who was infected with COVID and how to quickly do contact tracing, how to find out where people were. And for example, in Italy, which was hardest hit, the Italian government quickly passed a law that suspended elements of the GDPR that had been enacted in Italian law to allow government agencies to share data. They basically recognized that, you know what, they had never thought about a pandemic and this type of problem and hadn't really designed the law for that type of scenario. And they recognized how critical it was to address that, you know, within weeks. Now, obviously, when we're talking about the global digital economy and the digital economy, there's not that same urgency. So it's harder to get policymakers to respond in that same short period of time. I think it will likely be years before the European Union has a new draft of the GDPR or amendments to put forward. But even already, you know, the European Commission has issued a number of roadmaps this summer where they're looking at their European Union policy around AI, artificial intelligence. They're looking at the Digital Services Act, and all of these are touching on data protection and how data is collected and specific rights that are enumerated within the GDPR and how they might adjust that through new legislation. So even if they're not calling it GDPR 2.0, they're already looking at various changes to the laws based on the types of problems they've already found.
Wonderful, thank you. All right, so this we have another question, kind of drawing on some of the polling results that we had throughout the program. So based on one of the polls, 40% of respondents see a hybrid data protection regulatory model as positive. So can you provide your insights on what this might look like and when we might anticipate a first, you know, phase edition of this? What are the main drivers of this initiative and the main stakeholders?
So the main stakeholders are going to be the companies that opt into this system and the countries that support it. And that's where, you know, this global conversation around, you know, these shared principles of free trade and a recognition that the digital economy is what's spurring economic and social progress is necessary. You know, Japan, of course, deserves so much credit for being a leader on, you know, pursuing this idea of, you know, a global free flow of data with trust. Concept that I think resonated with so many countries because, you know, the free flow of data sounded good in principle, but people kept raising these objections. But, you know, the reason we don't want the free flow of data in these cases is always because we don't trust something happening over here. But again, you know, there's so many shared common values about what national security should look like. I mean, these are countries that are working together already on these issues. So, you know, I think it's possible to iron out these differences. But it's not going to occur when you have one country or one region being the rule setter for everyone, which is, I think, what happened with the GDPR. It was, you know, basically the offer was take it or leave it. You know, you can pursue an adequacy decision that the EU would grant another country, or you could not. And there was no middle ground. There was no alternative. And what's nice about the CVPR is there's a lot of flexibility built into the system by design. And I think that's what we need in this global framework. And as I said, you know, I think another opportunity here is around this concept of data trust, where, you know, we can start building, you know, global collections of data sets to address, you know, key problems we want to address, whether it's in cybersecurity, healthcare, manufacturing. There's a lot of opportunity, and there's a lot of kind of shared and common sectors where we should be working to quickly bring together data sets in ways that work within the existing laws. And I think that's possible as well. And I think that's part of that hybrid approach.
Great, thank you. Drawing off 2 points that you mentioned there, one on, you know, data trust, and then kind of this question around whether CVPR is not compatible with GDPR, or can we build them together? It seems there are some questions here. So one is, can governments like the US and Japan and industry do better to steer the discussion of building off the best of the GDPR instead of focusing on the alternatives? And would CVPR be compatible with that approach? That's one. And then on the data trust side, let me just pop that one in there too. How can we ensure effective monitoring and enforcement mechanism on data breaches to maintain trust? Would it be privacy by design?
So let me start with that first. I think privacy by design is a good concept for large companies. I think it's very hard to apply for small firms. You know, when you look at a startup or a business, 10 people, 50 people, a smaller enterprise, they don't have someone focused on privacy. And so this idea of privacy by design, especially when you have many businesses failing, it doesn't work. I mean, these companies are trying to create a product that is successful, and privacy is obviously very important, but so is security, so is usability, so is accessibility, so is low cost, so is energy efficiency. I mean, there's so many goals they're trying to maximize. They can't always start with privacy as much as we might want them to. That doesn't mean we can't bake in privacy earlier on. I think one of the ways to address that challenge is through the education system. You know, I have a computer science background, and when I was going through college and learning some of these things, you know, we did learn about security and we learned about privacy, but maybe there wasn't enough focus on it, and there certainly wasn't enough focus on it in some of the engineering principles, software engineering principles. And so, you know, I think bringing that into the curriculum is one way to support that. That's something that, you know, government can certainly support as it helps develop that curriculum and encourage universities to adopt these programs and certifications for graduating engineers and software engineers, electrical engineers. So I think that's part of the way we get to that issue. You know, and you know, building on that, that's also how we start getting to these ideas of maintaining trust. One of the problems with data breaches is that there's really no consequence and recourse for, you know, consumers and for companies. There's kind of an assumption that this might happen, and some companies are getting insurance for this, but there's not a lot of focus on how do you mitigate that. And that's where I think we really need to be focused on the actual causes of these problems. So for example, a lot of data breaches are because attackers are trying to steal data that can be turned into profits, information that can be used for financial fraud. They want information to be used for healthcare fraud. So we need to address those systems. How do we secure the financial system so that even if you get this information, you can't commit financial fraud? That's really the way to reduce the incidence of data breaches. And again, that's areas where there needs to be so much more focus and attention and cooperation between governments on those core issues. How do we improve authentication so that whenever you're signed into an online service, trusted electronic ID that in part is backed by the government and the private sector? How do we ensure we always have two-factor authentication? There's a lot of opportunity there, and I think that's where there can be more progress in the near future.
Wonderful. Thank you for that. We are running out of time this morning, so we'll do one final question today. Thinking forward-looking about, you know, how do we incentivize companies to get CBPR certified? And specifically here in Japan, it seems that there are a few companies that are currently certified. So why do you think that is, and how do we promote greater CBPR certification?
So I think some of this will start with awareness building. I think one of the reasons it's low is that, you know, again, I think many companies haven't heard of this, but also many companies are only just now thinking about these data issues. I mean, we've seen, you know, the massive investment in GDPR over the past few years, showing that a lot of companies just hadn't paid attention to this issue. And so they're exploring options. And I think as they are seeing some of the limitations of GDPR, again, even a company that is doing a lot of business with Europe, there's no reason you can't do both, right? I mean, that's, I think, part of the answer here is, you know, it should be GDPR plus for any company that's looking at GDPR. And some of that plus is going to be, you know, through the APEC framework here. And, you know, again, it's opening more doors, it's opening more opportunities. As companies scale globally, they want to be able to enter new markets. And so I think, you know, again, it's an opportunity to just grow and open new opportunities. And that's really the way it should be presented. You know, the goal isn't to punish companies and then pursue these frameworks. It's a way to enhance their businesses. And so I think if we continue to kind of lean into that approach, provide training, provide information about it, and share best practices, that's the path forward in this area.
Great. Well, thank you so much, Daniel, for joining us today. And thank you all to those who joined and asked many questions. We're so happy to have such great engagement this morning. So before we conclude, I would like to invite our audience to please participate in our event survey. You'll see the QR code popping up on your screen now. We'd love to hear your thoughts about the event. And we just want to say thank you again so much, Daniel, for joining us. And thank you all. And we hope that you continue to remain safe and healthy during these uncertain times. Thank you so much. Take care.